further hearing in the appeal. Taurus Petroleum Limited and State Oil Marketing Company.
Mr. Turning.
My Lord, in a moment I'm going to move on to the third head of the argument, namely, what if the collateral obligation analysis is correct? Is that obligation still protected by immunity?
Yeah.
But before I do, lest I haven't been clear enough as to why I say Mr. Pollock's argument is wrong, can I just, in 2 minutes, just recap why we say that his argument is wrong on the first issue? The special conditions here are not a mere add-on containing some collateral terms. The special conditions actually define the debt in the present case. And we say that for that reason, Lord Justice Briggs' analysis at paragraphs 60 to 63 is correct. And just by way of supplement to that, the general part of the letter of credit, if you like, the general terms, doesn't really address the substance of the debt at all. It is the special conditions which describe the debt or define the debt, and they tell us, those special conditions tell us that the letter of credit is not assignable and not transferable. They tell us that the debt is due in New York to the CBI's Iraq oil proceeds account. They tell us that it's effectively an arrangement cast in stone because the debt is due there irrespective of any contrary instructions from SOMO. And they contain an express engagement given to both the CBI and SOMO that payment will be made to that specified account. And we say that those key provisions that I've just summarized are not incidental provisions, they're not mere mechanics. They are essential to the description of the debt under these letters of credit, with the result being the 10 points that I listed yesterday. I won't repeat. And the effect, therefore, is that there is no debt due to SOMO or to its order. And that is why there is nothing for either a third-party debt order or a receivership to bite upon. And it is also why, if the court applies the Ferreira test of Lord Justice Floyd, namely, could SOMO obtain a court judgment in debt in its favour, the answer would be no, it could not. It could not obtain a money judgment in its favour because there is no money payable to it under these letters of credit. And that is why there can't be a third-party debt order applying Lord Justice Floyd's test. And for the same reason, the debt is immune because it is either due to the CBI jointly or with SOMO or solely. So now, with that introduction, I come to the third head of argument, namely, if that is wrong and the central bank is merely the beneficiary of a collateral promise sounding in damages, is that nevertheless property that's subject to immunity under the State Immunity Act and which immunity wouldn't be infringed if either the third-party debt order or the receivership order were to be upheld in the present case. And the relevant provisions, of course, are in the State Immunity Act, which you have in the core authorities at tab 8, starting at page 170. The court is, of course, familiar with the general structure of the Act. Section 1 deals with immunity from jurisdiction, and there are a number of provisions dealing with jurisdictional immunity. And then when one comes to section 13, there are what are called in the heading to section 13, this is on page 177, which is electronic 1820, there are in section 13 what are called other procedural privileges. So these apply irrespective of jurisdictional immunity, but create other rights. And the relevant one that we are concerned with for present purposes is 13 subsection 2b. The property of a state shall not be subject to any process for the enforcement of a judgment or arbitration award or in an action in rem for its arrest, detention or sale. And that is subject to subsections 3 and 4. 4 is what is generally called the commercial purposes exception, which applies in the case of a state, but does not apply in the case of a central bank. And
yes,
for
well,
that,
I think we know that.
and for that you get section 14.4. So there are two questions. So, what is property, which is not defined in the Act, and does it include the collateral promise sounding only in damages, if that is the true construction of the letters of credit? And if that is property, would the making of a third-party debt order or receivership...
How could there be a claim for damages if the debt is due to SOMO and is the subject of a third-party debt order in favour of some third party like Taurus? How could CBI have any claim for damages? It doesn't arise, but if it did have a claim for damages, how can you possibly say that the claim for damages is being subject to a process for enforcement of a judgment or arbitration award? It isn't. No one's trying to do anything to the claim for damages, but I don't think it exists.
Well, I'm going to address those 2 points.
Good.
Those are the two issues. Yeah. Is it property within the meaning of the Act, and is it then affected by these orders by 13 in such a way as to be protected by section 13.2b?
Well, a claim for damages, what's the basis for? It's obviously a property in some senses, in the sense it's a right. What's property mean in this context?
It means any contract. Well, it includes any contractual shows in action, whether that is a shows in action of debt or a shows in action for damages.
Where do we get that definition?
No, there's no definition in the statute.
I see.
This has been discussed in 2 cases. First of all, by the House of Lords in the Alcom case, and I can take you in a moment to what Lord Diplock said there. And he said that a contractual shows in action in debt is property.
But are you saying that if somebody brings about a state of affairs in which there is no point in exercising a right of action, that is a mode of levying execution on that right of action?
I am saying that it is having a direct legal effect on the relevant shows of action.
We're only concerned with one kind of legal effect, namely whether it constitutes levying execution.
Well, it says it's subject to any process of
enforcement.
Yes.
Right.
And if I will address that point. But I just address the first point that Lord Mance asked me about first, which is it property? And the answer is, in my submission, it is property.
Well, where's the authority? Let's look at it.
Well, just if I can just say the submission is that any shows in action for damages is property.
Just said it, yes.
And I rely, first of all, on what Lord Hoffman said in the ICS and West Bromwich as to the definition of personal property, which is subject to and capable of assignment. So that's in Authorities, Volume 1 at tab 18, page 148, Electronic Bundle 1966. And it's in the law report at page 915, which is Electronic Bundle 1985. It's in the Authorities Volume 1, tab 18, at page 148.
1985, yeah.
And it starts just below the letter C. And it says, "My Lord, I agree that a shows in action is property, something capable of being turned into money." Snell's equity defines shows his action as all personal rights of property can only be claimed or enforced by action and not by taking physical possession. Common law, for reasons into which it's unnecessary to discuss, shows in action could not be assigned. In equity, they could. Assignment of a debt or other legal thing in action was made possible at law by Section 136 of the Law of Property Act. In each case, however, what is assignable is the debt or other personal right of property. It is recoverable by action, but what is assigned is the shows, the thing, the debt or damages to which the assignor is entitled. And that was a case, ICS, where they were discussing an assignment of a claim for damages. So, as a matter of principle, my Lord, in answer to Lord Mance's question, a shows in action for damages is a species of personal property, and there's no reason why it should not be protected within the definition of property in the State Immunity Act. Now, the two authorities where this has been considered are ALCOM, which is, you'll find in the authorities, Volume 1 at tab 11, electronic 1855. And now this concerned a bank account, but a bank account is a shows in action. It's not, as Mr. Pollock says, it's not a pot of money or a bag of money.
Well, a bank account is a shows in action or a debt owed by the bank on a current account in credit. That's the shows in action, isn't it?
Yes, that's right. It's a shows in action in debt, but it is just a contractual shows in action. It's not anything else other than that. And therefore it falls within what Lord Hoffman was talking about as property, subject to being capable of assignment. And the relevant passage, I'm not going to detain you with the background, there's a very interesting discussion of the history of the State Immunity Act, but the relevant passage is on page 602 in the report, that's electronic 1877, or page 40 in the bundle, which is at tab 11. And he says, at D, my lords, I would accept that the expression property in subsections 2b and 3 is broad enough to include, as being the property of a banker's customer, the debt owed to him by the banker, which is represented by the total amount of any balance standing to the customer's credit on current account. It's erroneous and misleading to confuse the legal nature of this property with the legal nature of property that consists of cash or currency notes belonging to a customer physically lodged in a safe deposit. That's the point, but my Lord Sumption was just making it, it's a shows in action. And for the purposes of execution by attachment in garnishee proceedings by a judgment creditor, the customer's right to withdraw his credit balance is a single, not a composite, shows in action. And the super-added contractual obligations in respect of checks, that we needn't be concerned with the checks. So there's no doubt that what Lord Justice Moore-Bick called a bare contractual right, namely a shows in action in debt, is something within the definition of property if what Lord Diplock says is correct. The only question is a shows in action for damages also within the definition of property? And we say that it is, because property is given a wide construction under the State Immunity Act. The second authority that I wish to take you to is AIG Capital Partners and Kazakhstan, which is very...
I mean, I find this, the premise of this argument conceptually a bit difficult. I can understand that there's only a claim for damages if there's a contract, tripartite contract between A, B, and C, whereby A, B, and C contract that a debt otherwise due to A is due to C. Well, A may then have a cause of action, but it is simply for damages for failure to pay C. But if C is claiming under the promise, how can it be a claim for damages? I mean, the promise is a claim to pay C. Well, A, B, and C agree to pay C, and it's not a claim for damages, it's a claim for payment.
Well,
for debt.
Quite. That's my
I know.
primary argument.
Well, that's your primary argument.
So I'm arguing against.
All right, you're arguing on a hypothesis now which you don't accept, obviously.
Absolutely. I mean, that was why I started by saying that my primary argument is very much that this is a claim in debt which is owed either jointly or solely to.
So anyway, it might be more helpful if we were considering the first situation, which we aren't, namely where A, B, and C contract for something otherwise due to A to be paid to C. What's A's position? Only it's a damages claim, and then you'd have an analogy with this, but it's not this case, of course.
Well, I see that, but
you have an analogy with alcohol.
I only need to argue state immunity if I'm wrong on this first point of construction, because Mr. Pollock accepts that there is state immunity.
Yeah.
If I'm right on the first point of construction.
Yes, quite.
So I'm in a sense, the whole premise of this argument
All right,
is
the premise
against
is
me.
unsound, but nonetheless we're arguing about it.
Well,
What follows from it?
if the court tells me that I'm right on the I won't need to move. I won't need to deal with it. But if there's any possibility that the members of the court might
I'm
be
not saying the premise
adverse to me on the premise, then obviously this is my fallback.
Well, speaking for myself, I think the premise may well be sound.
Let's assume the premise is sound.
My premise.
Where is
Mr.
AIG?
Pollock's premise? Yes.
Okay. All right.
Well,
anyway,
we're talking about
We're talking about a pure damages claim, and
Yes.
you say it can still be property. Well,
Yes.
Why not? I suppose you
Yes.
say if a
It's
claim
not.
against-
I didn't understand Mr. Pollock really to be disputing that it was property which is capable of being immune from process of execution. And his real point, I think, is the point that was being put to me by Lord Sumption, which is it's not subject to levying of execution.
Yeah.
And my point is that is too narrow a construction of 13.2b, and 13.2b is wider than that. As he has, if I could just pause very briefly and just show you Mr. Justice Aitken's judgment in this area, because it was a very long, careful judgment on looking into the history of the State Immunity Act and the meaning of the word property. And I'll just take you to about 2 paragraphs in his judgment. And that is to be found in Core Authorities tab 2, Electronic 1666. Now, this involved immunity asserted by the Central Bank of Kazakhstan in circumstances where there'd been an investment arbitration award against the state of Kazakhstan, and it was being said that the assets belonged to the state of Kazakhstan rather than the Central Bank of Kazakhstan. And Central Bank of Kazakhstan successfully asserted immunity under the provisions that we've been looking at. And the immunity was successfully asserted in respect of bank accounts and also rights to deposit certificates.
Right.
Now, that's the background. The relevant passage is on page 1684, paragraphs 44 and 45 in the judgment. I won't take you through the build-up to that, but he says at paragraph 44, this is page 1438 in the law report.
1684, yes, we got it. Yep.
The word property in section 13.4 clearly refers to the property of a state, which is the phrase used in section 13.2b. So section 13.2b and 4 set out the rules on immunity from enforcement with respect only to the property of a state. It's noteworthy that even if a state can be sued because of one of the exceptions set out in the earlier sections of the Act, still it may not be possible to enforce a judgment obtained against it on that state's property in the jurisdiction unless the state's property falls within the scope of section 13.4.
Yeah.
There's no definition of property.
He just says it's as wide as it can be, doesn't it? That's
Yes. And the
we don't get
critical-
very much more from that.
The critical point is that just above H, he says, in my view, property will include all real and personal property and will embrace any right or interest, legal, equitable, or contractual, in assets that might be held by a state or any emanation of the state or central bank.
Yeah, okay.
So, now, there's no case hitherto has had to decide whether a contractual shows in action for damages is property within the Act, as opposed to contractual shows in action in debt.
Well, why shouldn't it be? I mean, use
But
your case.
Why shouldn't it be? Yes.
But hasn't your case got the problem that you're assuming that a contractual right of action for damages could survive the intervention by a relevant state through a third-party debt order.
Yeah, and that's the second question, which I'll now come to. So,
Right.
the first point is it shows an action for damages is property within the meaning of property in sections 13 and 14 of the Act.
good.
If I'm right on that, then the next question is, turning back to, if you've still got it in front of you, 13.2b,
Yes,
would the effect of a third-party debt order here be that the property of a state, namely the shows in action for damages, and here it's the central bank, is subject to any process for the enforcement of a judgment or arbitration award? And we say it would be, and therefore it is immune.
or when judgment or arbitration or an act in rem for its arrest, detention or sale.
Yes.
Yeah.
And my submissions on this are, firstly, that this phrase covers property which is caught up by enforcement, even if it is not the main target.
But the cause of action hasn't yet arisen. We're postulating
No.
that a situation where, because of the third-party debt order, the credit agricole is prohibited from paying, and whoever would otherwise get the money. Why would that involve a breach of contract by credit agricole in paying anyone?
Well, my lord, a shows in action exists, but before there's a cause of action, it may be at a potential stage, but it's a contractual promise that is, in certain events, enforceable.
So it's not the claim for damages, because you don't suggest that there would be a claim for damages against Credit Agricole in circumstances where Credit Agricole was prevented from paying by a third-party debt order.
I do suggest there is a claim for damage. Let me take it step by step. If in the normal event, if there was no intervention of a court order, if on this hypothesis, which Lord Sumption says I need to address, on this hypothesis that I've lost on the first point of construction, there's a collateral obligation sounding only in damages, according to Lord Justice Morbick and
well, if broken. And if they paid Taurus, Credit Agricole, that would clearly be a breach.
If they paid someone else, if they paid other than and in accordance with the letter of credit, that would be a breach. And I'm just addressing the situation without the intervention of a court order.
Yeah.
There would then be a cause of action. And to answer my Lord Hodges' question yesterday, he asked me what would be the measure of the damages. The measure of the damages would be the amount, prima facie, the amount payable under the letter of credit. So that is the shows in action that one has, that a contractual claim for damages in the amount of the letter of credit.
If there's a breach. But how could there be a breach if a third-party debt order precluded Credit Agricole from paying?
But there's a problem here where one breaks into the circle.
Yes, well, I think what you have to say, you have to argue that the third-party debt order deprives Credit Agricole not of a claim for damages, it deprives it of a right, don't you?
Well,
But it satisfies the right.
No, I think you meant to say...
Ceasing to exist.
You said Credit Agricole, my lord. I think you meant to say the CBI.
CBI.
I'm sorry, CBI.
Yeah.
Yes, I meant CBI. I did mean CBI, absolutely.
The trouble is that a third-party debt order is a mode of satisfying a debt.
Yes.
And so what you have to submit is that if, by operation of law, the debt is satisfied, that is a mode of enforcing against the assets of the central bank. And
Yes,
that seems...
well, a mode of enforcing is
there
a
yet.
paraphrase of section 13.2b. But yes, it basically, subject to us arguing about the precise wording, yes, is the answer to my
Now,
question.
how far do you take this? Do you say that any process of levying execution against an asset of a commercial party, if it has knock-on effects on the balance sheet of a central bank, Well, why not?
No, because it's not
Why
a
don't
question.
you say that if that...
Because it's a legal question, not an economic question. It's
No,
a
well,
question.
I don't doubt that it's a legal question. But as a matter of law, if a knock-on effect is good enough in this context, why isn't it good enough generally?
No, but I say a knock-on effect isn't good enough. It has to, that's my point. It has to have a direct legal effect on the right. And that's my point. It's not...
But how is it that the legal effect in this case is direct?
Well, I'll tell you...
What's happened is that you have levied execution on an asset, which at the moment we're assuming is an asset of SOMO.
Yes.
And the central bank, you say, has taken a hit as a result. Now, that's a knock-on effect, isn't it?
Well, can I lay it out the stages? But that is my submission anyway, that it does have a direct legal effect. Now, the situation here is a very unusual one, where you've got a debt, you've got one instrument, and the hypothesis we're looking at it's one instrument which contains a debt to SOMO, and within the same sentences, a collateral warranty as to how that very debt will be discharged. So the two, the debt and the collateral obligation, if it is a collateral obligation, are very closely connected. And anything which discharges the debt will undermine the collateral obligation.
So what is the
As a
test?
matter of
What's
law.
the test for saying it's direct? Because by definition, it's indirect in a sense.
Well,
But you quarrel with Lord Sumption's suggestion that it's any indirect effect. But it is indirect in this case.
It's
I appreciate
indirect.
it's in the contract and so on, but what makes it, quote, direct to distinguish it from any other case, such as Lord Sumption was putting to you in general terms?
Because it's the automatic effect of the Crédit Agricole would say, I'm not in breach, whereas I would have been if I hadn't paid you normally. I'm not in breach because I acted pursuant to this court order which told me to pay the debt instead to the judgment creditor.
Yes.
I still don't understand what makes it direct in the sense you say it has a direct effect and that's why it makes it different from other cases. What is it that makes it direct, given that if one's going to be strict, it's indirect, because otherwise we wouldn't be worrying about it?
Well, you're absolutely right. And that's, I don't know whether you've had a chance to look at my note about the Belhaj case, because there are some relevant dicta from my lords Mance and Sumption, and indeed yourself, but I think less so on this particular point, my lord. Because in the Belhaj case...
I agreed with them on state immunity. I don't think I had anything to say.
No,
on state.
This tension between direct and indirect was inherent in the dicta in the Belhaj case.
Would you want to look at the Belhaj case?
Well, yes. I mean, it's probably good enough to look at my note, which extracts the relevant passages.
Okey-doke.
And that is in the new bundle that was put in on Monday, called Supreme Court Authorities Respondents Supplementary Bundle with electronic references. And it's Respondents Note number 1.
Yes.
Which is entitled, just to give it its context, why there should be a broad interpretation of the phrase subject to any process for the enforcement in section 13.2b.
Sorry, just say, what is it called?
It's called Supreme Court Authorities Volumes Respondents Supplementary Bundle.
Okay, thanks.
That's it. I mean, all of this discussion in Belhaj is concerned with the circumstances in which you can indirectly impede a state by attacking its property, albeit that the nominal defendant is a non-state, whereas we are addressing the question now on the assumption that the relevant property is SOMO's. If it isn't, if it isn't SOMO's, we don't get into it.
No, I'm addressing. Sorry, I'm addressing this on this hypothesis. The relevant property is the CBI's shows in action for damages.
I see. Okay.
Where I'm still struggling with respect, I don't want to take you out of order, but I would still
like an explanation as to why the measure of damages is the amount payable under the letter of credit if the debt is SOMO's. And I wonder whether the right conferred by the collateral promise is simply a power on the part of the CBI to prevent Credit Agricole or SOMO from paying the money elsewhere.
Well, it could be. I mean, there's no reason in principle, my lord, you're right, that it should be restricted to a remedy in damages.
I don't think it's being put to you it's restricted. I think it's being put to you that there isn't a claim in damages. It's a right to either a negative injunction or possibly even a specific performance. But it doesn't sound in damages.
That's a form of a contractual relief which is unknown to me, a contractual term that if it's breached does not sound in damages.
Well, it's not that it would sound in damages if there were any, but it's hard to conceive how the damages would actually arise.
But that's really my point.
Oh, well,
if I agree with you, I will pay X £100 and I don't. What's your loss? That's the basic question.
No, but I'm not. In this hypothesis, we're talking about the rights of the central bank. The central bank's loss is it hasn't been paid. We're not talking about the loss of SOMO. This is the property of the central bank that I'm discussing here. We're talking about a claim for damages owned by the central bank, a shows in action owned by the central bank. And so the central bank is in your example, my Lord Neuberger, the central bank is the person to whom the money has been promised to be paid, and its loss is the loss that flows from not being paid.
That I think takes one back to the. If you are wrong on the construction of the letter of credit, which is the hypothesis on which you're making this submission, the reason why you will have been wrong, as I see it, will be that the correct analysis of the special clause B is that it's an obligation to meet, an obligation owed to CBI to meet the obligation owed to SOMO. Now, if that's the correct characterization of it, which is really the basis on which, if you lose on that point, you will have lost, then where does the damages come? Well, because the breach consists of failing to pay a sum of money to SOMO. And in what sense would CBI have been any better off if the money had been paid to SOMO?
Well, that's where if that is the construction, then I can see your point.
But that's what you have to assume.
My construction is not, and as I understood it, Lord Justice Moore-Bick's construction was that the CBI would have a claim for damages for the payment not having been made to the CBI.
Sure about that.
And that's the hypothesis on which I'm addressing the court. That the CBI, after all, this is a contract which, whatever else it has those words, we hereby engage with CBI and SOMO. So there is a direct contractual engagement with the CBI that payment will be made to the CBI. And that is...
It's a claim by CBI against whom?
Against Credit Agricole. And it's that cause, that's the cause of action, rather the shows in action, that I'm currently addressing as being property of the CBI, which would be directly legally affected by a third-party debt order, or a receivership order for that matter, because the Credit Agricole would in effect be discharged from having to pay those damages to the CBI. It would be the shows in action will be nullified.
Well, not if the correct analysis is that it's a collateral obligation on the part of Credit Agricole to perform its obligations to SOMO, because it will have performed its obligations to SOMO if the debt is garnished, because it's a mode of satisfaction.
But I agree, if that is the correct construction, but my answer is that isn't the correct construction, even on this hypothesis, because there is a direct engagement by the Crédit Agricole to the CBI that it will pay into the CBI's oil proceeds
So
account.
you say that will be effectively subject to a process for enforcement if the third-party debt order comes in and prevents that being happening.
That's it.
It's really the end of paragraph 9 of Lord Justice Morbick's judgment on page 8, where he's
Yes.
putting forward Mr. Pollock's contention, which he effectively accepts. And you say it's really the last 3 lines of that.
Yes.
Is that right?
That's right. That's right. And while we're looking at it,
Yeah.
we do. Can I also draw your attention to paragraph 36 of Lord Justice Morbick's judgment?
Thank you.
Because he effectively accepted this analysis on the receivership aspect, but didn't, with respect to him, carry it through. So in paragraph 36, he says, there is the question of the effect of the receivership order on other parties, in this case principally the CBI, which is not resident in this country and is not a party to the proceedings, but is the beneficiary of a promise by Crédit Agricole to pay the sums due under the letters of credit into its account in New York. A receivership order would effectively prevent it from obtaining the benefit of that obligation. That's precisely, and that's why we say that section 13(2)(b) is invoked. But it's triggered not merely for the receivership order, it's triggered for the third-party debt order as well. Now, I hope at least I'm making myself clear. Whether members of the court all agree with me, I hope that I'm at least making it clear what the case is, that we say that that is right, paragraph 36, but he hasn't extended it to the extent that he should have done. Now, just on indirect impleading, though of course I am sure that the court was focusing on other matters in Belhadj, there are nevertheless the dicta which we have set out in this note. And
if the bank had, if Crédit Agricole, sorry to interrupt, if Crédit Agricole had in a separate agreement, subsequent to the letter of credit a day later, at the request of, if a day later, the request of CBI, they'd agreed with CBI to pay it into that account, would you still be able to run this argument? In other words, it was a genuinely collateral later agreement.
well, if it was an assignment, we certainly would.
No, if it is just a later agreement on these, assume there's a perfectly straightforward letter of credit between, for the benefit of SOMO, specifying the money will be paid to the CBI, but day later, Crédit Agricole, for some reason, enters into agreement with CBI that it will pay it into that specific account.
We would.
That would be a collateral arrangement.
But it would still be...
Would 13(2)(b) still bite?
Yes, it would, because it would still be intimately connected with the discharge of the debt. It would be an agreement as to the manner in which the debt will be discharged. But in this particular instance, we have a trilateral arrangement.
I understand that.
In the very body of the instrument.
That's why I asked the question.
But my answer is yes, it would still be the same, my lord.
Thank you.
Because it would still be an intimate connection between the debt and
it does seem to me to follow. I agree.
Yeah.
Thank you.
And
but your position is even if it doesn't follow, this case is special because it's all in the same contract. Understandable.
yes.
Yep.
And if I can just very briefly remind you of the passages in Belhadj which we have in mind.
Yes.
We have set them out in this note, if you have it in front of you now.
Yes.
If, for example, if we take it 3.1 on page 2 of the note, the second passage in bold in the citation from Lord Mance at paragraph 15, where he says, Lord Atkin also identified a second situation of immunity in which, even though the state may not be a party, the proceedings relate to state property. Now, we need to transpose into there, even though the central bank may not be a party, the proceedings relate to central bank property. And Lord Sumption, if we go to the bottom of the page,
Yeah.
the emboldened passage, it reflects a broader rule that if a relief claim would directly affect a foreign state's interest in property, now transposing there a foreign state central bank's interest in property, it makes no difference whether the action is framed in rem or in personam, and no difference whether it's brought against the central bank or someone else who is in possession or control of the property. And then Lord Atkin, this was reflecting something that Lord Atkin had said in the Christina, so we see this over the page in the emboldened passage. The second is that they will not, by their process, whether the central bank is a party to the proceedings or not, seize or detain property which is his or which is in his possession or control. Now, this is then reflected, as you may recall from that case, in the UN Convention on State Immunity, and that's what we set out at Article 6.2b, that a state enjoys immunity from jurisdiction in respect of itself and its property, even when it's not named as a party to the proceeding, provided the proceeding in effect seeks to affect the property of that state. So the relevant connection is, does it affect the property of the state? And then Lord Sumption discussed 6.2 in the passage which we've set out in paragraph 6. I'm not going to read all of that out. And then Lord Mance similarly over the page, where he says that the drafting history locates Article 6 firmly in the context of the case law concerning the rest of vessels and property in which states claim an interest, and goes on to say that it has to have a direct effect. So this is my Lord Neuberger, this is why there is a slight tension between the phrase indirect in pleading and nevertheless having a direct effect or affect on the property, because that reflects the common law and the UN Convention.
Indirect in the sense that it is the consequence of action taken against the party. But it's got to directly affect the legal interest of the state in its own property. And the problem, as it seems to me at the moment, is that your submission involves saying that if a contractual right is less valuable because of external events, that is something that directly affects the legal interests of the state in its shows of action.
But as I said, I don't say that. I don't say it's a question of value.
That's what you have to say if you wish to pray and aid this case in your support, in your favour.
No, I say that it has a direct legal effect because the making of a third-party debt order or receivership order provides Credit Agricole with a cast iron reason for not paying the Central Bank of Iraq.
It provides them with a defence.
Yes.
But, I mean, that's not the same as actually interfering with the shows in action. It just means it's not as valuable as it would otherwise be.
That's the question. Is it the same as interfering with it? I mean, I agree. We're on the same territory, my lord, but we characterise it differently. We say it is interfering with that shows in action for damages, because it is effectively nullifying it by providing the third party, providing the bank with a cast iron defence.
Does it come back down to a matter of construction of the letter of credit? If the letter of credit obligation, the collateral obligation to CBI, is subject to a condition that it won't apply if the making of payment is frustrated, or if the third-party debt order intervenes to satisfy the payment in a different way. If that implication exists, then the shows of action was always qualified. Whereas if the shows of action is, you say, there and is positively interfered with by the third-party debt order, that's within the Act.
Yes.
Is that a matter of construction of the letter of credit?
Well, that's Mr. Pollock's argument, that the letter of credit obligation is subject to that implied qualification. And our answer to that, we have four answers.
One would have thought that that was the. I mean, isn't that the normal? Wouldn't that be the normal implication anyway? You've got four answers to it. If you do divide it into the principal debt and a collateral obligation.
Well, first of all we say there's no basis for reading that into the letter of credit. First point. That's my second point is. Nothing could contribute more to the uncertainty of letters of credit than to start reading into them rather uncertain implied terms, absolving the bank from liability in certain situations, because the one thing the seller wants is certainty.
Well, the bank must be absolved from liability itself, Credit Agricole, by a third-party debt order, so why shouldn't collateral obligee be subject to the same principle?
But it could well be another bank, for example, which has advanced money on the faith of the letter of credit, and it's therefore had itself put into the letter of credit as the payee. And I mean, it would be astonishing then for that bank, having advanced money on the faith of letter of credit, to suddenly find.
But I mean, if this submission is correct, then it would mean that you couldn't you couldn't garnish a debt, even if the CBI had nothing to do with this, and it was simply the only obligations owed were owed under the letter of credit to SOMO. If this submission is correct, does it not follow that because the letter of credit requires payment to SOMO, and the result of the garnishee order is that it's actually paid to the judgment creditor, there's a breach of the letter of credit? Surely not. And if that is so as between SOMO and Credit Agricole, then what's the conceptual problem about it being equally true as between CBI and Credit Agricole?
But, my lord, this is why I say it depends on where you break into the circle. Because if you start from the position of what would be the obligation of Credit Agricole absent the court order, Credit Agricole would be under an obligation to pay damages in this situation to the Central Bank of Iraq. The court order, that is property in the hands of the Central Bank of Iraq. And the court order is then taking away that property, but it is legally destroying that property by providing Credit Agricole with a cast iron defence to it.
Not destroying the property. It is simply an external state of affairs, which means that the property is there, but no loss has been suffered, because an overriding operation of law has altered the nature of the obligation.
Well, my lord, if that's what Parliament intended, but we would respectfully submit that Parliament can't have intended immune rights to be destroyed by measures of enforcement not directly targeted at the immune person. So,
well, the trouble about that is that on the other way of looking at it is to say that Parliament is unlikely to have intended that merely because there was a collateral obligation to an immune entity, you can't levy enforcement against a non-immune entity.
well,
So that all you need to do in future with state trading organisations is to have the obligation, so to speak, franked by the CBI or by the country's central bank. And Bob's your uncle, it's completely unenforceable against anyone.
but that is the whole policy argument. I don't know whether you've had time to look at Mr. Blair, as he then was, article which we've put in. But there are policy reasons why central banks have been given very wide immunity, and they're not subject to any sort of commercial purposes exception. And there are good reasons. In fact, they're discussed by Mr. Justice Aitken in that judgment, the later part of the judgment, paragraph 82 as well. But
could I just put a possibility to you? Suppose that A agrees to sell a property to B, and B has agreed to on-sell it to a state.
Or a central bank.
Or a central bank. A creditor of A comes along and executes against the property, preventing the completion of the contract between A and B. Would the state's the state's contractual rights under its contract with B would be effectively undermined.
Yeah, but
Would,
there wouldn't be the direct connection in that case.
You say that wouldn't be direct?
No, because our case, the reason why our case is different and why it harking
I mean,
back,
why wouldn't it be direct connection? Because it's the same.
Because of because this debt and the collateral obligation are all within the same paragraph, if not the same sentence, of this letter of credit.
So it depends on the layout of the document, does it?
Not the layout of it, but the intimate connection of the two obligations.
So in my example, your answer would be different then.
No, it wouldn't, because they would still be intimately connected.
No, because in my example, it was the day later that they entered into, the contract is entered into between Crédit Agricole and CBI. That is very similar to Lord Mance's example.
But if a day later all three parties agreed,
all three
then that maybe that if you're contemplating, perhaps if you're contemplating that only two parties agree, then it is different.
That's the very example I put to you.
But my lord, I'm sorry, I perhaps hadn't appreciated you were talking about.
I probably didn't make it clear. Yeah,
two party. But in our situation, the two are intimately connected, and that is why.
So it is essential, or important to your case, that it was in the same contract. It was all part of the same document.
Yes. I mean, we actually say it was all part of the same promise, but.
Well, we have to make sure that which assumption we're making, and at this point we're assuming against you that it has the meaning which Lord Justice Moore-Bick said.
But my lord, even if it is against, if that is against me, we still can't be denied that the "we hereby engage" to both is all in one sentence, indeed.
Well, yes.
So
What you engage to do is to perform the obligation which is identified earlier in the main obligation part of the letter of credit, which is to honour the documents as correctly presented, which is an obligation on the hypothesis we're on now, owed to SOMO.
Well, my lord, in fact, when you look at the earlier part, it doesn't actually say, I mean, the earlier part simply has the amount and the documents and the expiry date, and everything else is in the special conditions.
Well, no, there's the identification of, which was in Lord Justice Moore-Bick's view critical, the identification of SOMO as the beneficiary, with all that entails under the Uniform Customs and Practices.
Yes.
You say it can't depend on that can't depend on how the contract's laid out. I mean, there's a single arrangement here. That's your point.
Yes. It's single
However
arrangement.
it's laid out doesn't matter, surely. It would be ridiculous if which came first or whether it was part of the same sentence.
No, but they are in substance intimately connected, because one is the debt and the other is, on this hypothesis, a directly connected collateral obligation as to how the debt will be discharged.
The point is, it's all part of the same arrangement.
Yes.
And
They say it's plainly collateral. There we are, that's it. I mean, that's the question. And there's a limit to how long we can go on arguing.
Well, I was going to say
your
something
clerks
to the
had
same
enough of
effect.
Just remind me where the UCP were.
Well, Mr.
separate document.
Mr. Pollock handed you a
separate document, or they're the first thing
that's
in
amazing.
the authorities bundle.
Very helpful.
yeah.
Yes.
So I mean, the hypothesis which I'm addressing you now is that the last sentence of paragraph 12 in Lord Justice Moore-Bick's judgment is correct, that there is a separate collateral obligation to pay the proceeds into the CBI account, which is owed to the SOMO and the CBI jointly and sounds in damages.
Yeah.
So, but so far as the UCP is concerned, you had my submissions yesterday on the dictum of Lord Justice Mustill, and the fact that it is there to fill gaps, as it were, rather than to dictate the outcome.
Well, I mean, I think it's important not to undermine the binding effects of the UCP, not simply because it's incorporated into the contract unless expressly displaced, but because the uniform rules are the only basis on which letters of credit are able to operate on a common basis internationally.
Absolutely, yes. Yes. But these are very, as we've seen at great length, these are very unusual letters of credit. And they don't conform to the norm. Now, if I may, I will move on.
I think Lord Clark would be pleased if you did.
Well, I don't mind if you've got a completely new one. Anyway, there we are.
Well, I think
Let's move on.
I've been answering the questions as best I may,
Yes, yes,
and I've
right.
been repeating myself
I'm not blaming
because I've been answering questions.
Yes.
Now, the lex citus.
Sorry.
Now, as the court will appreciate, the crux of the issue here is, in general, when you have a debt under a letter of credit,
Yeah.
is the jurisdiction in which the debt is payable, which is likely to be the jurisdiction of the seller, or at least the jurisdiction which the seller has asked for payment in? Or is it the jurisdiction where the issuing bank is resident, which is likely to be where the buyer resides, or where the buyer, for his own convenience, has asked a bank to open a letter of credit? Which of those two jurisdictions is it in which the debt is situated, with the lex citus of the debt? That's the critical issue here. And Power Kerber obviously decides that it should be the former, the place of payment, rather than the latter, the place of residence of the issuing bank. We say that case has stood for 35 years. It hasn't caused any problems that one can detect in any of the writings or decided cases. It is supported by a strong policy argument which acknowledges the special nature of letters of credit and places the interests of securing payment for the seller at the foremost. Letters of credit are special, and the principal obligation under them is treated in English law as being a very special obligation. The whole raison d'etre of letters of credit is to give the seller security of payment, and can I just list what we consider are the special features of letters of credit?
Yeah.
Or dicta concerning letters of credit which reflect its special features. There are many dicta, which I won't trouble you.
Are these summarised in your case?
They are, yes, but we've quoted, for example, I think Lord Diplock, but there are many dicta to the effect that letters of credit are the lifeblood of commerce and such like. I'm sure the court is familiar with those. The whole idea, and this is absolutely critical point. The whole idea of a letter of credit, it's meant to give the seller the nearest equivalent to cash in his hand at the place where he resides, or where he has chosen to be paid.
Yep.
Now, obviously, it's not cash, but it's to be as good as you can get without actually giving the cash. And letters of credit, for this reason, are very different from other debts or other instruments creating debts. And English law has developed a number of features, which are now reflected in the UCP as well, to protect that seller's right to as good as cash. Firstly, and I'll just list these features, if I may, why letters of credit are special. First of all, as Mr. Pollock said yesterday, they are an unusual species of contract because they are irrevocable as soon as the bank issues its letter of credit.
Yep.
I think he said it's not even a unilateral contract, it's a special species.
Yep.
Secondly, and associated with that, there's no need for the seller to pass consideration to the opening bank to support the binding nature of the obligation.
That's really the same point, isn't it?
Yeah. Thirdly, they operate autonomously, in other words, independent of the underlying transaction. Fourthly, they are triggered by simply presenting documents and nothing else.
Yeah.
And following on from third and fourth, fifthly, only evidence of fraud can prevent them from being operated.
Clear evidence of fraud.
Yes. The United City Merchants case. It's not in the case, but it's very well known. And then sixthly, English law has traditionally regarded letters of credit, both under the common law and under the Rome Convention, as governed by the law of the place of payment. And one can see, on the one hand, the convenience of saying that the citus, the lex citus, is the same as the applicable law, and one can see, on the other hand, the inconvenience of saying that the lex citus is different from the applicable law. So we say that those special features of a letter of credit support the policy argument in favour of power curber.
If you had a bog standard debt, contractual debt, and the contract provided that a UK resident debtor was to pay in New York, exactly the same issue would arise, wouldn't it? I mean, that particular point is surely equally true of ordinary debts which do not arise under a letter of credit. That you are liable to find that the proper law of the debt, which is likely to be the place of performance, is not the same as the lex citus if you undertake to discharge a debt in a place where you do not reside.
Well, the problems of that nature can occur, but what I'm saying is that English law has chosen to protect letters of credit by hitherto deciding that the governing law, the applicable law, and the lex citus are the same, namely the place of payment. And if it were otherwise, it might create delays and uncertainties in payments under letters of credit.
Why would that be?
Because there could be an inconsistency then between the lex citus and the governing law.
Well, the obligation would only be governed by the governing law unless there is an overriding operation of law, nationalisation, execution and so on, which may be where the lex citus is.
That would be true if we were within a hermetically sealed legal system, just the English legal system. But the way we characterise things then depends on how we treat matters that happen in other countries. So power curber, for example, is a perfect illustration. Characterise the lex citus as being the place of payment, and that then depends on how one treats the provisional attachment granted by the Q80 court.
Well, if the lex citus is Carolina, the provisional attachment is a fortiori irrelevant, isn't it? I mean, your argument is that the risk of letters of credit are meant to abstract the relationship from the underlying contractual relationship, and one might think, perhaps, from the debtor or the underlying contractual debtor, and if you associate them with the law of the place of the issuing bank, that's likely to bring you back to an association with the underlying contract debtor.
That's absolutely right.
Whereas if you treat it as the same law as the place of performance, that's going to be either a neutral or at least a place where the debtor can't interfere so lightly.
Well, in the case of a letter of credit, the place of payment will be either the seller's residence or where he's asked to be paid. And in either case, it's fair for him to be subject to legal risks in that jurisdiction.
I mean, you can choose your issuing bank, assuming that you habitually deal with Credit Agricole. You can basically get the letter of credit issued by any branch you like of Credit Agricole. It's not necessarily a choice that corresponds to anything concerned with the underlying contract, and under the UCP, each branch will be treated as a separate bank.
Yes, my lord, and that is a point we actually pray innate. So consider the facts of the present case. The seller contracted to receive payment in New York.
Yes.
We can see that from the underlying sale contract. The buyer was one of the Shell group of companies based in Singapore, and the seller was Somo, which is in Iraq. England had no connection with the transaction, except that the Shell company based in Singapore asked a London bank rather than a Singapore bank to open the letter of credit. It could, as you say, have asked a bank anywhere in the world. Now, what if if the buyer had said, well, I know Republic A is a country where they're very prone to granting provisional attachments over letters of credit. I will ask a bank in country A to open this letter of credit.
You're envisaging that the seller will have some special interest in a third party attaching the assets?
No, I'm not. I'm thinking.
No, the buyer wants to protect themselves in case they later discover that they'd like to avoid paying under the letter of credit.
Yes.
Well, I mean, I think that's right in this sense that we're talking about Shell, and it's most improbable that they would, any such thought would cross their mind. But most letters of credit transactions that one comes across, in my experience at any rate, or many, you just go to the local bank to get the letter of credit issued, and then one does see sometimes attempts to interfere in the local jurisdiction with the performance of the letter of credit.
Yes, but you do normally go to your local bank, which is the buyer's residence. Yeah. But what if a particular country became noted for being prone to issuing provisional attachments, and therefore buyers said, well, we will go to that country and we'll ask them to open the letters of credits, because we know we can then go to the local court in that country. After $200 million worth of oil has been put on a tanker and is sailing on the high seas, and to prevent the bank making...
You'd have to get an agreement to that effect from the seller, wouldn't he?
No.
Why not? Because
the seller only stipulates the pace of payment.
The seller can stipulate whatever he likes. He can say, I want a letter of credit from a UK-based or a Singapore-based or an American-based bank, and such clauses are actually very common. They identify the sort of issuer which they are prepared to accept.
That is correct. That is
Yes,
correct.
but that's why it seems to me this argument is rather arid, because it strikes me that if there is a problem, the seller can contract out of it.
Well, yes, but
I mean, don't you normally ask? And this may be lead to the same conclusion, but would you normally try to dictate the issuing bank, or would you not try to dictate confirmation by some other bank?
Yes, and the confirmation or advising will be at the seller's end.
Yes, but that would be how the seller would deal with this problem. So I don't mind who issues it, but I want it confirmed.
Exactly.
As indeed the contract said in this case.
And then, my Lord Hodge, then what the seller then does is he refuses to ship until there is a confirmed letter of credit confirmed by the bank in the place where he which he has chosen for the confirming bank.
The confirmation just simply shifts the same set of questions to the jurisdiction of the confirming bank. It doesn't make any difference to the analysis.
No, I agree, and there's my Lord Mance will recall a case called Bank of Baroda, Vyasa.
Oh yes.
Yes, where he held that was under the Rome Convention, not under Rome I, but he held that all the contracts ought to be regarded as subject to the same law, otherwise there would be a manifest inconvenience, and the place of payment to the ultimate beneficiary, the seller, should be the overriding consideration. And I'm going to take you to
In
that.
choosing the proper law.
In choosing the proper law, and then you have my submission that traditionally English law has regarded the lex situs and the proper law as marching hand in hand for similar reasons of protecting the interests of the seller under a letter of credit.
Well, has anyone looked at, as a matter of interest, at continental law on this? Is there any German or authority or French?
I'm afraid we haven't.
No.
We have looked at Commonwealth, as you've seen from
Yes, I saw that.
our
But,
note.
and
And there is one Quebec case,
yes.
which I suspect is not really continental, but it may be infected by continental considerations, where power curber has been followed, and that's in our note. And that, when I say the note, just for the purpose of identifying it,
I mean, see,
that's the second note in this additional bundle that came up on Monday.
Yes.
it's quite possible that the power curber has also penetrated the continent.
Well, it is possible. We will look.
I'm very surprised.
We will look. You say it's possible. It is possible, but it actually surprisingly little authority, even in the Commonwealth countries. You've seen from our note that they're mainly extracts from Halsbury's laws in those countries, rather than.
Well, when
decided
does the
cases.
problem arise? The problem arises, A, at the stage of jurisdiction, and B, I suppose, in the type of situation we were discussing, where somebody tries to do something which can be regarded under the lex situs as affecting the validity of the obligation under the letter of credit. They try to get it embargoed, confiscated, banned, etc.
Yeah.
And then people start to say, well, that's only relevant if that's the lex situs. So those are the two situations. And you
Yes,
say...
I think somebody mentioned exchange control possibly, but it's difficult to see. Normally, exchange control and any problem with arranging the payment is for the buyer. If you located the debt in the place where the buyer's bank is, it might have some effect in relation to exchange control as well. But essentially what we say, my lords, is that there is no evidence that power has caused any difficulties in international trade.
Yep.
It doesn't have any reasoning. We don't really know why.
No, that's actually...
well, what is their reasoning?
No, their reasoning is the points that I've been making about the lifeblood of commerce and the critical importance that letters of credit are not interfered by the bank in the place where the buyer is located. My lord, what happened is, when you look at their judgments, that bit of their reasoning is in the stay part of the judgment. But it's still there in the judgment, that they're very well aware of the policy considerations.
The policy considerations were not to grant a stay in circumstances where that would prevent the letter of credit from being honoured in accordance with what they had already held to be its terms.
Yes. But this is not the most refined judgment, but it was clear that the court had in their minds these policy points. They just referred to them in the part of the judgment where they dealt with the stay, rather than the part of the judgment where they dealt with the lex situs. And you can see that if you look at the relevant parts of, and we've set it out in our case, in fact, where the relevant parts of the judgment on the stay are, reflecting these policy considerations. Now, obviously, it would have been neater if they had cross-referred or referred to these policy considerations in relation to the situs point, but there can't be any doubt. If you go to Dicey, for example, Dicey says that clearly these policy considerations played a part in their decision, and they are understandable policy considerations. Now, if I could just... so we've also summarised, I don't know if you've managed to locate all of the relevant passages, but we've also summarised the textbooks on this that we've been able to find, and that's on paragraph 116 of our case. My Lords, Mr. Pollock has not advanced in our submission any reason to overrule Power Kerber, other than to say, well, it would be neater and tidier to diminish the number of exceptions to the general rule. But as I hope you've seen from our case, the English law on the lex situs of intangibles and shows in action is not particularly neat and tidy in any event. We've set this out in the, if you have the case.
Yep, paragraph.
We make some introductory comments from 79
Yep.
through, and then we discuss the so-called ordinary
85.
general rule 84, and then we mention at 87 how it's explained by Lord Atkin in the
Yep.
New York life insurance case. That was a case where, following World War I, property of German nationals was to be used to pay reparations. And the question was it property within the UK? And it was, the relevant property was sums due under life insurance policies. And were they due in London or were they due in New York? And he explains the background to the rule, being one of convenience. Then we set out at 89 that the rule is subject to many exceptions. And at 91 that there is an imperfect link with recoverability. And at 92 that there are other place of payment cases. And I wanted to draw, if I may, particular attention to the passage in Dicey at paragraph 96 in the case, because this is the point that I think Lord Sumption had in mind yesterday about the American bank accounts. And in English law, if we just read the passage which is set out from Dicey, where debtor has two or more places of residence, creditor either expressly or impliedly stipulates for payment at one of them, then the bank will there be situate. This refinement is important in connection with bank accounts, where, as in English law, under the applicable law of the contract between banker and customer, the bank's obligation to repay is performable primarily at the branch where the account is kept. So it's important to note that this rule about bank accounts is another rule that's based on the place of payment, on the place of performance, place of payment of the debt.
Well, it's actually based upon the proposition that in branch banking, for certain purposes, you treat branches as if they were separate entities, and they are therefore resident in the place where the account is kept. I mean, that's the analysis in, for instance, National Westminster Bank and Zhang and similar cases.
Yes, but then having found that, the place of performance of the obligation is that place. Yeah. And therefore the rule
but
is...
only because it's necessary to choose between various places where the debtor is.
Of course.
Yeah, so still the underlying rule is that you're seeking the place where the debtor is. And if there's more than one, then you choose the place where the debtor is and has agreed to pay.
Yes, And in the case, but all I'm making is the point that that's another illustration in
No,
the
we
case
see
of
that.
banks of place of payment, place of performance, being the relevant
Yes, yes.
place. And incidentally, Lord Denning did refer to that rule in, as I say again, in the stay part of his judgment in Power Curber. So he obviously had that rule in mind in Power Curber. So that's the background, and then we go on to say in paragraphs 98 and following that there are no good reasons to depart from Power Curber.
Yes.
There is the dictum of Lord Diplock that I referred to about the function of a letter of credit, or as I've called it, the raison d'etre. I've given you a list this morning of a number of additional features. I listed 6 features of letters of credit which do make them special. And then at 101 we deal with the proper law point, the applicable law point, so far as the common law and the Rome Convention is concerned.
Sorry, I was simply clearing my throat.
That's all right. And there is the dictum of Mr. Justice Mance in the Bank of Baroda case, where he says it's of great importance to both beneficiaries and banks concerned in the issue and operation of international letters of credit that there should be clarity and simplicity in such matters. Article 4.5 provides the answer. And if we go to the Rome Convention, just briefly.
I mean, do we? Is this really likely to be controversial?
Well, I don't think I think Mr. Pollock says that Lord Justice Morbick was correct to say that English law was the applicable law of these letters of credit.
But I mean, given that the applicable
yes,
law and the lex situs are not necessarily the same, whichever may be the situs, whether it's the residence of the debtor or the place of payment, it's a fact of life that it's liable not to be the same as the jurisdiction of the proper law. So simply identifying the jurisdiction of the proper law and pointing out that the place of performance is the critical factor in this, as it generally is in the law of contract, doesn't necessarily get you very far.
Right. Well, where I submit it gets me is 2 points. First of all, this is the reason why letters of credit are regarded as being an exception to the normal residence rule under the Rome Convention is because the critical feature of a letter of credit is the security of payment in the place of performance. And that same feature is the reason why the lex situs should be regarded as the place of payment as well.
Yep.
But there is another reason why the proper law might matter, and that is that it goes to the receivership issue. If we get on to that,
Yeah.
because as Lord Justice Morbick said, if the proper law is not English law, that is a strong reason not to grant a receivership order.
Yes.
So we've then set out the relevant passages from various textbooks explaining the policy considerations in paragraphs 103 all the way through. At paragraph 108, we draw attention to the passages in Lord Denning's and Lord Justice Griffiths' reasoning, which I've mentioned. For example, at 110, Lord Denning said, letters of credit, it's vital that every bank which issues a letter of credit should honour its obligations. Courts of any of the countries should interfere with the obligations of one of the banks. It would strike at the very heart of that country's international trade. And Lord Justice Griffiths made a similar point at the end of the paragraph 111. The whole purpose of this form of payment is that a seller should not be kept out of his money by litigation against him at the suit of the buyer. In the absence of fraud, the seller is entitled to be paid. So that underlines that they had in mind those special characteristics which justify a different rule in this area. And if you go then to paragraph 112, you see that the editors of Dicey agree in paragraph 22-033 that those passages formed the basis for the citus decision. And we say the majority therefore had well in mind the policy reason for deciding the citus issue the way that it did. Then moving on to 114, judicial consideration, there doesn't seem to have been any judicial criticism of the principle over the last 35 years or so. Academic criticism seems to be absent. We've pointed out what the various authors say, and including, as I mentioned yesterday, at 116 subparagraph 4, Dr. Rogerson's article in the Cambridge Law Journal, referring to the special character of a letter of credit in the commercial world being to protect the seller and ensure payment to him of the price. And she said that this may justify a different rule as to citus from that applicable to an ordinary debt. And then we say there's been no industry criticism of the of this rule, and Mr. Pollock has not pointed to any. So for all those reasons, we ask the court to uphold the decision of the Court of Appeal in relation to citus. Moving then to the receivership question, we submit that this court should uphold the decisions of both the Court of Appeal and the Commercial Court and discharge the receivership order, applying the principles laid down by the Court of Appeal, Lord Justice Collins, in Masry number 2. There's no dispute that the relevant principles were identified by Lord Justice Collins in that case, in particular at paragraph 59.
Yep, which you create, yep.
Which we have set out.
Yep.
And we submit that Lord Justice Morbick did not err in his application of the relevant principles. And indeed, there are some more points that he could have made which favour discharging the receivership order. Before I go any further, I would like just to show you, if I may, the receivership order itself, and that is in Appendix Part 1, Tab 10, page 65.
Yep.
And paragraph 1, you see that, this is on page 65, the claimant do, if so advised and subject to approval of court, nominate a receiver to receive monies receivable in respect of the defendant's interests as beneficiaries of letters of credit. And the jurisdictional issue that arises in relation to this letter of credit is that the monies, and this is regardless of the points on which we've argued so far, that the monies receivable, the actual money, is not receivable in England and is only receivable abroad. So even if the claimants somehow get over the problem of central bank property immunity, they still face the problem on the face of these letters of credit that there are no sums receivable in this jurisdiction. Now, the Masry case was a case where it was held that there could be an extraterritorial receivership order in support of execution of an English judgment. But that was a very different situation, as my Lord Neuberger will recall, because he was sitting in that case in the Court of Appeal. In the Masri case, the defendant had submitted to the jurisdiction of the English court and contested the case on the merits. Now, throughout the proceedings on the merits, and then there had been a judgment of the English court given against the defendant after he had submitted on the merits and contested in full the merits in the English court. In the present case, what has happened is that we had a Baghdad arbitration, an arbitration seated in Baghdad took place. There were no merits proceedings in England. And what then happened is that on a particular day, a couple of years ago, maybe 3 years ago now, the claimant applied to enter judgment under section 66, I believe, and also to obtain third-party debt order and receivership, all done ex parte. And that was at a time when my clients had no connection with this jurisdiction at all. They had not participated on the merits in court proceedings. They had simply participated in an arbitration seated in Baghdad. And they immediately indicated that they intended to contest the jurisdiction. The reference to the acknowledgement of service, it's in the bundle, it's bundle 3A, tab 22, page 139, E bundle 886.
Yep.
So turning then to the three factors that Lord Justice Collins discussed at paragraph 59 in Masri number 2.
Yep.
First factor is the connection of the person who is the subject of the order with the jurisdiction. That is here SOMO. SOMO has no connection with this jurisdiction. It's an Iraqi state entity. It has no presence here. It does not conduct business here. There's no evidence other than what we're arguing about in this case, that it has any assets here. It doesn't have any bank account other than in Baghdad, apparently.
What's the status of the challenge to the jurisdiction?
Well, this has been pursued by challenging the orders.
No, but how can you? I mean, this is an attempt to enforce an arbitration award. That's something that Taurus are entitled to do in this jurisdiction. What's the basis on which you challenge the jurisdiction here?
Well, you don't do.
Well, we haven't challenged. We indicated that we did challenge the jurisdiction.
Yeah, but you don't. You can't.
We've not participated.
You're resisting the orders.
We've not participated. Well, we haven't sought to set aside the judgment.
No.
But we are resisting the third-party debt order and receivership order.
So you are here, rightly here, as litigants. The question is, what powers does the English court have?
Yeah, but the question of whether we had a connection with the jurisdiction has to be judged on the day when the orders were made.
Well, the way they put it is this, isn't it? It was entirely predictable, they say, that if SOMO failed to honour an arbitration award issued pursuant to an arbitration agreement, which it had entered into, they would find it in an English court under the Rome Convention. And it's the policy of the English courts to uphold international arbitration. And what do you want?
Well, we say it's not entirely predictable because we don't have any business or assets here. We don't have a presence here.
Well, subject to the issue.
Subject to the point we're arguing about.
But I mean, that's the point, isn't it? It's not a question where you would expect to end up. The whole principle of the New York Convention is that you can enforce it anywhere where there's some assets.
Yes.
And if there are some assets,
yes.
It's hard to quarrel with this as an appropriate place to pinch them.
Well, No, but that's not the point that Lord Justice... look, the first point he says is, what is the connection of the person who is the subject of the order with the English jurisdiction?
Yep.
That's the point I'm addressing. Not whether our assets have got some connection with the jurisdiction, but whether we, SOMO, have any connection with the English jurisdiction. And my point is, we had no connection with the English jurisdiction at all.
Well, can I just get straight? You both referred to Section 66, which normally is familiar in the context of domestic arbitrations. But this is a Baghdad or an Iraqi arbitration, and my Lord's just referred to the New York Convention. Why isn't this a New York Convention subject to Section 101 and 2 and so on? Case. Is Iraq party to the New York Convention?
No, it's not.
It's not. So it has to be done as under Section 66.
I think that's why they did it that way. Yes.
Right. Well, all the same, Section 66 is evidently wide enough to enable one to...
Oh, yes. But it's...
In an arbitration award is, in a sense, something which is potentially enforceable everywhere, isn't it? In any country.
Yes, I mean, it's not, as you say, Iraq is not a party to the New York Convention, so we're not in a New York Convention situation, but they have obtained a judgment based on the award under Section 66.
All right. So you say it's got to be something preceding that. That's bootstraps, holding yourself up by your own bootstraps. Yes.
And I mean, and in the court below, and it may be that Mr. Pollock will raise this in reply. He said, because I heard him saying something which you may not have heard, but he said the money's been paid into court now. But that can't help him. That is bootstraps, because Crédit Agricole, the judge at first instance found that Crédit Agricole had paid the money into court in response to the court order.
Yes. So, I mean, the question is whether the court order should have been made,
Yes.
And if it's discharged, presumably the money will come out of court and go to someone else.
Yes, we'll go to New York, go into the bank account in New York. But, my Lord, and just in case Mr. Pollock does pursue that point any further, monies in court, as your Lordship may recall from a case where I think you were counsel, called Halvanon, money in court does not belong to the person to whom it might ultimately be paid to. It belongs to the person that pays it in. So it's a debt owed by the court. Well, it's actually the general account, I found out, but it's by the let's say, the account of the government to the person who paid it in, which is Crédit Agricole here. So that's the money in court is a debt owed to Crédit Agricole. And in any event, the judge at first instance found that was only paid in response to the court order. So it would be bootstraps to rely on the fact that there's money in court. Right. So as at the point in time when those ex parte orders were made, the only, that my client had no connection of its own with this jurisdiction.
You have that point.
Yes. And it had not contracted to use a London bank.
Yeah.
That was Shell's unilateral choice.
Yep.
And the underlying transaction had no connection with England either.
Right.
And the place of payment was expressly chosen as New York. So you might have expected that if they were going to try to intercept any monies, they might do it in New York, but because that was the place of payment. So my clients, unlike the defendants in Masery, have never submitted themselves to any adjudicative process of the English court. They have simply contested these orders having been made against them ex parte.
Right.
And they've never submitted any aspect of the merits to the court here.
Would we be standing on our heads if we said, if we accepted your submission on lex situs, that the lex situs is in the United States, we said for the purposes of a receivership order, it is highly relevant that not only is this being enforced as a judgment in England, this award,
but it is in practice only enforceable against Credit Agricole, who are here in London.
Well,
We can go and whistle in Carolina or New York.
they're also in New York, but
It was said in New York, went it by you or by whoever, that it's only the right people to get are the people who agreed to pay at the place where they agreed to pay. Receiver will, practice will go along to the doors of a Credit Agricole and be able to enforce by mandatory order, contempt of court and so on in London.
yeah, they as it happens, the money has been paid into court. But if Credit Agricole had insisted on making payment to the receiver in accordance with the terms of the letter of credit, it would have had to insist on making payment in New York.
I see. So what's the receiver going to do?
And that's not a lex situs point. That is simply a contractual point.
So the receiver, he must be, the receiver must be there appointed with a view to instructing some other sort of payment other than to CBI in New York. What is a receiver going to do in practice?
No, but it's absolutely Hornbook law that the receiver simply steps into the shoes of the contractual rights of the parties.
Yes, I see.
And he can't rewrite the contract and say, I would like it paid somewhere else or to someone else.
Yeah.
That's why I say that the terms of the order, which I showed you, really highlight a fundamental problem here, which is irrespective of state immunity, irrespective of lex locus, that you can't, the receiver doesn't have power or jurisdiction to rewrite the letters of credit.
No.
And that's what Lord Justice Morbick agreed with us on.
Yes, I understand.
So a third-party debt order is a more powerful instrument because that
There's
can
no
order.
use to them.
Yes.
The receivership order is no use to them, you say.
Well, it shouldn't be made
That's
because...
a different point. But you're saying it doesn't really matter because they can't do anything with it when they got it.
No, I'm not saying that, my lord. And what I'm saying...
So what can they do with it?
It's an inappropriate remedy to be granted in an extraterritorial context if the three criteria...
What use can they make of it? Suppose this part of the case fails, on your part of the case fails. What if any use can they make of it? Maybe you don't want to make any concessions about that. But...
Well, I imagine what they would do is if this part of the if they won on the receivership order, they would then seek to argue that they're entitled to the money that's been paid into court. But that is the bootstraps point. That is just a short circuiting of the contractual arrangement. The contractual arrangement was to make payment in New York.
Yes.
And it can't be that because Credit Agricole didn't put up a fight and just said we'll pay the money into court to abide the outcome. It can't be that they are in a better position, because that would be effectively allowing Credit Agricole, in response to a court order, to rewrite the terms of the letters of credit.
I see. Yep.
So
A third-party debt order is a more powerful weapon then, because a third-party debt order, if properly made, can divert.
yes, I mean that is what its function is.
It overrides the contractual obligation by operation of law.
Yeah.
Yes, absolutely. We haven't looked at those passages. I mean, this is all discussed at great length in Societe Aram. And in particular, the nature of the relief is discussed by Lord Hobhouse, Lord Hoffman, Lord Millett. But yes, absolutely, it is redirecting a debt by operation of law. But that is why you can't do it if that debt is A, not owed to the judgment debtor, or if it's immune, or if it's not situated in England.
Yes. Yep.
On the first of the three criteria or considerations, we say that Lord Justice Morbick was correct to say that SOMO has a very tenuous connection with this jurisdiction, if any. Tenuous was his word. Then the second consideration is whether what they're ordered to do is exorbitant in terms of jurisdiction. Well, we've just strayed into that, because it is exorbitant, because the payment is due to be paid in New York, not in London.
Yeah.
And then the third question is whether the order has impermissible effects on foreign parties, and we say that it does, because of its impact on the CBI. And that is so whether it's the CBI is owed the debt, which would be a fortiori, but even if it only has a mere contractual right of any kind, it is still being unfairly affected in having that contractual right interfered with.
Thank you.
And what it really comes down to is it a sufficient connection that Shell, of their own accord, decided to use a London bank to discharge their obligation to make payment for this oil? Because there's absolutely nothing else to do with England under this transaction or under this letter of credit.
You say Lord Justice Morbick was wrong to characterise the proper law as English.
Yes. Now that's the next point I was going to come to, because he considered that and decided that it was English law, and he rejected our argument that it was New York law. But you can see from his judgment that if he had held that it was New York law, then he would have considered that was a further reason why there should not be a receivership order.
Yep.
And this is paragraph 35.
Yep.
And where he says,
Yes.
it's necessary to identify the proper law, because unless it is English law, a receivership order could well place Crédit Agricole in the invidious position of being required to pay the receiver to avoid being in contempt of court without obtaining a good discharge of its debts. Yes. And now, so he correctly identified the relevance of this issue, yes, but then decided it wrongly, in my respectful submission.
Understood.
And he decided it wrongly because he ignored our submissions about the displacement rule in Article 4.3 of the Rome I regulation. We did make those submissions, and they were our skeleton, and we briefly made them orally as well.
Right.
But he didn't mention them in paragraph 35. And we say that that is wrong, and that this, following the decision of my Lord Mance, as he then was, Mr. Justice Mance, in the Bank of Baroda case,
Yes.
this is a situation where the law of the place of performance should be regarded as displacing the residence rule. And so if I could just take you quickly to the relevant provisions of the Rome Convention.
Yes. Yes.
The Rome Convention is in Authorities, Volume 4, I believe. No, I'm sorry, it's right at the back of Volume 3.
Thank you.
Authorities, Volume 3,
3.
at tab 34. This is electronic 2431.
Yep. Yep. Where do you want us to look?
And if you want to keep a finger in Rome 1, it's the immediately preceding the tab.
Thank you.
And this, so it's Article 4.
Yep.
Let's start with the Rome Convention.
Yep.
Applicable law in the absence of choice. This is on page 2432.
Yep.
And the displacement rule at the time of the Rome Convention, being the only relevant law, was 4.5 on 2433. Paragraph 2 shall not apply if the characteristic performance cannot be determined, and the presumptions in paragraphs 2, 3 and 4 shall be disregarded if it appears from the circumstances as a whole that the contract is more closely connected with another country. And what was held, both at common law and then subsequently under this, was that the place of payment is the place with which the contract in favour of the beneficiary is more closely connected.
Right.
Now, going back then to the previous tab, Rome 1, Article 4 has been reworked, and it now starts with a list of cases. So it's still entitled applicable law in the absence of choice.
Yes.
But a list of cases A to H of specific rules. Then in 2, one gets the rule of the law of the country where the party required to effect the characteristic performance has his habitual residence. That's the residence rule.
Yes.
And then it's now 4.3, which is the displacement rule rather than 4.5. And it's been simplified, but also had the word manifestly added. So it now reads, where it's clear from all the circumstances of the case that the contract is manifestly more closely connected with the country other than that indicated in 1 or 2, the law of that other country shall apply. Now, under the Rome Convention, it was held by the Court of Appeal in the Marconi case, which is in Authorities Volume 3, tab 29.
Yes.
That the central importance was placed on the place of payment. And that is, as I say, Volume 3, tab 21. And the key passages are paragraphs 61 to 63 on 2253 in the electronic version.
Right.
And in particular, in the judgment of Lord Justice Potter, in paragraph 62, but it's really, it's 61, 62, and then some general discussion, and then 66. Stressing the key importance of the place where the payment is to be made. And my Lord Mance reached a similar conclusion in the Bank of Baroda case, which is in Authorities Volume 1.
Well, isn't that followed in this case? I mean, the Court of Appeal was following the Bank of Baroda, or at least following it, it was agreeing with the result. It quotes extensively from it.
I think...
2250 and 2251.
Yes, that's right. I've got them in the wrong order. You're
Yeah.
right. Yes, but your, my Lord, the key parts of your judgment, which are in tab 12 of Volume 1 of the Authorities, are in the electronic bundle numbering at 1888, and in the left-hand column, which is page 93 in the law report.
Yes.
Where you said at the bottom of the left-hand column, in my judgment, this is
this is all set out on page 81 of Marconi.
Yeah.
Yes.
It's very passive.
I'm sorry, I hadn't appreciated
okay.
which way round they came. But you said it would be quite wrong to stop at Article 4.2, and this was the case where you could go to 4.5, and you agreed with if you look at, well, it's not paragraph numbered, but on the right-hand column, about 10 lines from the bottom of the right-hand column, you said, I agree with the editors of Dicey and Morris, the application of the law, the place of performance would in such a case still be likely to result by application of 4.5, as it did applying the common law, illustration for an offshore international, which is the case that we've referred to in relation to the common law. Now, the question, therefore, is, does the reasoning of yourself, Bank of Baroda, the Marquis case, does that reasoning still apply, despite the somewhat different wording of Article 4.3, as opposed to 4.5? And we say that it does, and there's been no decision on this by a court as yet, but Dicey seems to be in our favour on this point, and that is in the Authorities, Volume 4 at tab 35. I'm sorry, that's Benjamin. Tab 39. Just a moment. At electronic 2486, yes, it's paragraph 33-317.
Which page?
It's page 2486 in the red numbering,
Thank you,
electronic
that's fine.
numbering, or 46 in the...
No, I only need one, thank you.
Yep.
Yep.
And
Yep.
they discuss the common law, first of all, and then the position under the Rome Convention. So picking it up, let's say 10 lines from the bottom of the page. Accordingly, in cases dealing with the formerly applicable Rome Convention regime, it was suggested it is submitted correctly that it was possible to avoid this undesirable result by invoking 4.5 of the Convention, deciding that the law declared applicable through Article 4.2 should be displaced in favour of the law of the country where payment is to be made against presentation of conforming documents. The same solution appears possible under the displacement provision in Article 4.3 of Rome 1, especially as recital 20 to the regulation makes clear that one of the factors to be taken into account in determining whether a manifestly closer connection with another country exists is whether the contract in question has a very close relationship with another contract or contracts. So cautious endorsement of the same rule being applied under 4.3.
And on 2485, also under 33-315, same view can also be supported by reference to the rules contained in the Rome 1 Convention.
Yes. Yes. And we have one other textbook that comments on this, and that is Benjamin's Sale of Goods. That is in tab 35 in this bundle. And it is discussed at the end of the section, which is headed banking contracts, and it's in the red numbering 2448. Page 8, the governing, and this is 5 lines down the page, the governing law may, however, be displaced under Article 4.3. In this respect, account should be taken of recital 20. And the same point as in Dicey. Hence, as with the Rome Convention, it may be possible to invoke the displacement provisions so as to avoid applying different laws in the context of credit, and to apply the law of the country where payment is to be made against presentation of documents.
And they also cite Fentiman, I see, on that point in the footnote. 708 is Richard Fentiman's book,
Yes,
so maybe another.
Yep.
yes. Well, we can have a look at that. Now, so, my Lord, we have two submissions on this. One is that should be the general position for all letters of credit, but in any event, these particular letters of credit are obviously closely connected with performance in New York, given the special provisions and the requirement to make payment in the way that we've discussed into the special Iraq oil proceeds account. And no other payment can be made. So whereas in other letters of credit, that instruction can be countermanded or it can be overtaken by an instruction to make a payment elsewhere, in this particular situation, the payment could only be made by Crédit Agricole, and that was effectively written in stone, as I've called it. Now, both the courts below fell into error in not accepting our arguments on this point. Mr. Justice Field erred in paragraph 18 of his judgment because he held that Crédit Agricole had to make performance in London, and that was wrong because it didn't have to do anything contractually in London. And Lord Justice Morbick said that was wrong, and he didn't agree with that.
Right.
So all that it had to do was to make payment in New York, and as Mr. Pollock has told you, that was done by instructing JP Morgan Chase in New York to make payment into the CBI account at the Federal Reserve in New York.
Yep.
So nothing was being done in London, still less something which was the characteristic performance, or the gives this the close connection with London.
Yes.
Lord Justice Morbick fell into error because in his paragraph 35,
Yep.
which we've looked at, he
Yep.
did not agree with Mr. Justice Field,
He was right about that.
but he was right about
Yep.
that.
Yep,
But then
okay.
he ignored our argument on the displacement provision 4.3.
I see.
And he didn't refer to the
Yeah.
authorities on that. And he should have applied 4.3 following Dicey, Benjamin, and the reasoning in Bank of Baroda
Yes,
and the Marconi case.
yes.
And he should therefore have held that New York law governed. And that then is a further reason, if that is right, that is then a further reason why there should be no receivership order, for the reason given by Lord Justice Morbick in the first 6 lines of paragraph 35,
Yes.
namely that it might place the bank in jeopardy.
We've seen that, yep. Yep.
So, my Lord, unless I can answer any further questions or assist you on anything else, those are my submissions.
Thank you very much indeed, Mr. Dunning. Mr. Suishi. Thank you. Mr. Pollock.
My Lord Clerk asked me for an aid memoir yesterday, which I have if he still wants it.
Yes, please.
But what I've done, to make it easier, I think, is I've simply photocopied the 2 sheets of Jack, which contain the relevant material. But I'll give your lordship my aid memoir as well. It's got some other stuff on it. I have removed from it my annotation in manuscript, which made a comment about one of your lordships. I hope you don't mind.
What, the comment or the removal of it?
Right?
You don't mind the comment or the
No,
removal
I
of it?
hope you don't mind removing the comment.
If we don't know what it said, we
I've
can't
reprinted it. It wasn't insulting, my lord.
Is this the only
Was
copy?
it insulting?
It wasn't insulting in any way.
Well, I wonder if I could have a copy of this.
You could. You can have a copy of my aid. There's my aid memoir.
Edited
I think I may have given Lord Clark 2 copies of Jack, and I was going to give you the other one. I'm so sorry.
So am I the only one who's allowed to have
You're
it?
only allowed to have one. And
I see you just given it.
no other of your lordships asked for it.
That goes
I
back
saved
to-
paper.
Well, we might wish to keep control over Lord Clerk by ensuring that we have copies
Well,
of
we
what...
will
Well, I
ensure.
will undertake to have a copy to my
Right.
It just tells
the
you
purpose of the
the
court.
different forms of letter of credit.
Right. Thank you very
How
much.
payment
Pollock.
takes
Right.
place.
They probably know all about that already.
No.
Very well.
Now, my lord, a fault line in my respectful submission, which runs entirely through my learned friend's argument on the main issue, which is the construction of the letter of credit, is a failure to distinguish between the concept of a sum being owed as a debt and the concept of the discharge of that debt by payment to a third party. And there is a constant problem in the propositions that he puts to you that he uses payment in two entirely different senses. Payment in the sense of this is how money is handed over for the purpose of discharge, and payment in the sense of I owe the debt. I have to pay X because I owe him the debt. Now, a debt which is owed to X, if at X's behest it's discharged by payment to Y, the debt is still paid to X. It's even though X has not received a penny. So my friend constantly saying, oh, Somo will not get a penny, doesn't mean that the debt wasn't owed to Somo. All it means is that the arrangement between Somo and Crédit Agricole was that the debt owed to Somo would be discharged by payment to a third party or into a third place. And you can, I mean, a homely example, if I'm owed money by X and I say to X, I want my wife to buy herself something nice, would you mind giving the money, making the check payable to her, and payment is thus made to her, it doesn't mean the debt wasn't owed to me. It doesn't mean the debtor has suddenly become my wife because I have not received any payment in cash in my pocket and she's received a check. The debt has been paid and discharged when I suppose the check is honored. And if you ask yourself, suppose the check is dishonored, who is going to sue my creditor? I am, on the debt. My wife may have a separate cause of action on the check, but that is a separate cause of action from the debt. Now, it really is quite important that one keeps these conceptual differences in mind, because it is only by doing so that you can approach properly the construction of the letter of credit and what is supposed to happen under it.
That's a simple situation, but
Yeah.
this is a more complex situation, isn't it? This is a situation where A, B, and C have all got together, and in relation to a sum which is normally and otherwise payable by B to A, they have all said together, this will now be payable irrevocably to C instead of to A. Now, in that situation, A can't unscramble that. I mean, this is a letter of credit. It's immutable. And A has no right, does A, to sue for it. A can't claim that it should have been paid to A. The only complaint is, the answer would be, you've made a contract, you've now agreed that this is paid to C, and that's it.
Well, it is to be paid into a nominated account.
Yes.
Now, suppose there had never been any promise set out in the letter of credit to the CBI.
Yes.
And you had an absolutely standard form of letter of credit where you started off in favor of X, the documents were then specified, and after that, the promise was made by the issuing bank that upon due presentation and performance of the conditions, X amount of money will be paid into, and then you have a defined account. Now, there's nothing unusual about that.
Well, the
that is
obvious example would be a case where there was a chain of contracts of sale,
Yeah.
and you simply arranged for the payment to be made further up
into the last account. Now, your lordships really do have to grasp that, because it's a problem with my friend's argument that there is nothing at all unusual in a bank account being specified in a letter of credit, which is not the bank account of the beneficiary, into which payment will be made to discharge the debt, to perform the opening bank's debt.
Given that, what is unusual about this case is that the owner of the bank account is made a party to the deal and is given a right to have the sum paid into its bank account, and that is the only right which exists under this letter of credit in relation to payment.
But then what your lordship is doing, with great respect, is simply failing to analyse what the right is. When you say he has a right, what right? Do you mean the debt? Do you mean he is now owed?
I have a right to payment,
no,
which is a debt.
He has a promise. A promise is made to him,
Yes.
along the lines, I, Crédit Agricole, will perform my obligation, which I undertake to Somo, by, as I have promised to Somo, paying the money into this nominated account.
Yes.
Now, the fact that it happens to be an account in the name of the CBI is possibly, I mean, can be accidental. Suppose you had a situation where the nominated account was the oil proceeds account held in the name of Somo at some bank. But you had a promise in the letter of credit to the CBI as well as to Somo that the only place this debt will be paid is into the Somo number 3 account, or the oil proceeds account in the name of Somo at such and such a bank. What you need to think about, or what you need to have in mind, is really a concept of a series of boxes. The money is paid into a box. This is what the intention is under a letter of credit, that you identify the box into which money will be paid for the purpose of discharging the debt. Now, and in physical days, you could do that. You could simply have boxes and the money gets popped in. But no, but it's exactly the same concept now. You have a box, and one of the functions of the letter of credit is to define the box into which the money is to be paid in order to produce performance and discharge of the letter of credit obligation. Now, it really doesn't matter in whose name that is. It can be all over the place, as my Lord Sumption says. It can be someone who's down a chain. It can be someone who is a creditor of the beneficiary. There can be all sorts of reasons. Now, in this particular
Or it can be the beneficiary's banker.
if one is entitled to take into account anything underlying, but you can guess even if you aren't. You say, right, there is a reason in this case why people wanted to be sure that Somo couldn't get together with Crédit Agricole and divert the money. So you make a promise which will require the third party to agree to diversion. It's just an additional security means that it's got to go into a particular box so no one can walk away with it. Now, that could happen for all sorts of reasons, whether Kuwait and all the rest of it, or any other reason. You can do that. But it doesn't make the third party to whom the promise is made anything other than the recipient of a promise that performance to the beneficiary will take place in a certain way. And that is simply a collateral promise. It's nothing more than a collateral promise, which may or may not have effects. Now, before I forget, one little point I should make. Close to his closing remarks, my learned friend said that one of the special features of this letter of credit was irrevocable and so on, couldn't be changed. Now, all letters of credit are like that. At the end of the day, the beneficiary of a letter of credit cannot change the terms of a letter of credit to ask that payment be made somewhere else than that which is specified in the letter of credit. He and the opener can get together and they can amend the letter of credit, i.e. you can effectively produce a new credit, but in this case, unless Crédit Agricole agreed, payment always had to be made into that particular account in New York. And that was the method specified in the letter of credit as the way in which payment would be made to discharge the debt. And time again, I have repeated this, but I do it again, there is a difference between saying money is owed to X and the question of how that debt is going to be discharged, how it is going to be performed. Now, and that is the simple way to make sense of this particular letter of credit. It's not a very unusual letter of credit in many ways, insofar, well, in every respect, other than the fact that the CBI has a promise made to it that the method of performance will be paid into a certain account. It is totally usual in the sense that you will always get provisions such as those special provisions, particularly that special provision which you get saying, if all presentation is done and everything else is there, we will pay into X. That is a normal provision, because unless what you plan to do is just to leave it for negotiation by documents against some counter or other, if you intend to have the issuing bank pay into a particular place, you have to specify it. And whether you specify an account which happens to be in the name of the beneficiary or in the name of a third party has nothing to do with to whom the obligation is undertaken. So it is really very, very important to make sure that those concepts are kept in mind. It is equally important to keep in mind, for the purposes of the argument, the distinction between a debt owed as a shows in action and the proceeds after discharge. Because my learned friend consistently slides in his argument between looking at who owns or can do something with the proceeds and who can do something with the debt before you get to the proceeds. Now, this being the case, in our respectful submission, there is nothing paradoxical at all in what Mr. Lord Justice Moore-Bick stated, that you can have a situation where the debt is owed to X, but X is never actually going to get into his hands the money because of arrangements have been made for the debt to be discharged by payment to a third party. Now, let us suppose I open a letter of credit in favor of X, and I say, this is a letter of credit for sum so much payable against presentation of the following documents, payment to be made into account number XYZ at the G Bank in the name of ABC. Now, just suppose that as a letter of credit, and that's not an unusual form of letter of credit. Is it going to be said, well, that means the person in whose name that particular account is held, thereby must be the beneficiary, either joint beneficiary or, my friend's primary argument, the only beneficiary.
Sorry, what is the premise here? Just start.
The premise is, my lord, a letter of credit is opened in favor of SOMO, well, in favor of X. You have the usual term about what documents have to be presented and so on.
Yeah.
And then it provides, as many letters of credit will, specifically, that payment under this letter of credit, once documents have been properly presented, is to be made into, and then you say, account 12345 at JP Morgan, which account is in the name of Gordon Pollock.
Yeah.
Now, that is a perfectly proper and ordinary letter of credit. It tells you who is the beneficiary, who is the opening bank, and where the money has to be paid once the documents have been presented in order to discharge the credit. And
it gives Mr. Pollock no rights.
It would give me absolutely no rights.
It merely identifies the account as being in your name.
No one in a million years, let alone any banker, would look at that and say, "Oh my goodness, Gordon Pollock is actually the beneficiary under this letter of credit."
But actually, in this case, we have the agreement with Gordon Pollock, as it were, that it will be paid into his account.
But why should that make any difference? Because if what
Say
you
that's
wanted,
a natural contract.
if what you wanted was to make Gordon Pollock either the beneficiary or a co-beneficiary, then you would simply put my name in next to Somo. When you say, I mean, you've really got to give some major weight to the fact that a letter of credit drawn up in normal form names X as the beneficiary. Now, the additional provisions may be there for all sorts of reasons, and we can guess the reason in this case. It's in order, as I said, to prevent anyone fiddling about with the destination of the money. But that doesn't alter the nature of the obligations and the fact that all you're dealing with is setting up a particular system, or a particular rule for the discharge, and you're adding a security device to stop that being altered. That's all.
Does he?
Now,
Yep.
Now, that leads us to the question of, well, briefly, to the question of your account, as it appears in those two paragraphs. Now, it is perfectly proper to refer to an account held in the name of a third party as your account when a letter of credit says payment will be made into your account. What is implicit in those circumstances is your nominated account, the account that you have nominated for the purpose of receiving payment of the sum owed to you. And if in the next moment you are referring, and that is then identified, as we can see in this case, your nominated account is the account in the name of the CBI at a particular place. And if you're making a promise to the CBI that you will perform your obligation to SOMO by paying into that account, then of course you're going to mention the same account. There's no contradiction between those two. And it does, we would submit, seem obvious that if the bank fails to honor the credit, there can be no doubt that the only person able to sue is the beneficiary. And that's again a question that comes up in discussion between your lordships, my learned friend, from time to time. It is suggested in this case, as I understand it, that if Crédit Agricole simply failed to perform, that SOMO would not be able to sue.
You're talking about suing for the debt.
Debt would not be able to sue.
Do you accept that the CBI could sue, as it were, for specific performance of the hereby engage obligation or not?
Well, it is possible, I suppose, that you could envisage.
But otherwise, it's a contractual agreement, which is...
You've got a promise to a third... What you've got is a promise to a third party that I will perform my obligation to the second party.
Exactly.
Now, if that is so, if a promise is made to a third party, a binding promise, A enters into a debt, an obligation which gives rise to a debt owed to B. For whatever reasons, he then enters into a separate contract with C, saying, I promise you, C, because you have a good interest, or you've got some interest in this, that I will perform my obligation to B.
Well, if you say, just going back to your simple point about Mr. Pollock being owed some money and saying, please pay it to my wife to get her something nice. Now, if I'm the debtor, and I actually say, I hereby agree with Gordon Pollock and Mrs. Pollock that I will pay the money I owe to Mr. Pollock into Mrs. Pollock's account.
Yep.
is there an agreement that she can enforce? Why not?
Well, yeah, of course.
But you say it's a collateral agreement.
It's collateral, but it's a separate agreement
Right.
from the original debt. That's
Yep.
the whole point. Is
That's right.
just as in a letter of credit you have a whole bundle of separate agreements dealing with mainly the same subject matter, whether it's a nominated bank, the conforming bank, and so on. There's nothing inherently difficult in the idea that you can owe a debt and owe a collateral promise and make a collateral promise which creates an obligation to a third party that you will pay that
Well,
debt.
no, why can't Mrs. Pollock sue for the payment, subject to question of consideration possibly? What, if I have promised to pay the money I owe you into her account and I promised it to her, why can't she sue me for it?
What is she suing? Your lordship really has to think about this. What is her cause of action?
Well, the question is, it's contract, because I've agreed.
No,
Unless there's absence of consideration, I've agreed.
Is it in debt or is it in damages for breach of a promise? Now, there is an enormous distinction.
Or is it an action for specific
we
performance?
Back in the days of the
I don't understand the
causes
concept.
of action.
I don't understand.
Forms
Well,
of action.
maybe because I'm not. I don't understand the distinction between claiming a debt and claiming damages for non-payment of a sum of money to me. If the sum of money is owed to me, why isn't that automatically a debt? Why do damages claims come into it? You know, take me back to the causes of action.
But you see, your lordship jumps over because it's saying owed to me. And that's the point. It's not owed to you.
Well, what does owed to me mean, except
promise-
it's been promised
the
to me?
promise being made to the CBI is not, we will pay you the CBI because we owe you money. It's, we promise you that we will discharge the debt owed to SOMO by paying the money owed to SOMO into this particular account. Now, let's make it easy to follow, because what you say is, suppose the promise was not to pay it into an account in the name of the CBI, but to pay it into the account of X. So you have a letter of credit, and then you have the collateral promise to the CBI, saying we promise that we will discharge, we will pay the money we owe under this letter of credit into the account of X. Now, that's a perfectly good promise to the CBI. I assume it's supported by consideration. It's a perfectly good promise, and if it is breached because Crédit Agricole pay somewhere else, then the CBI would have a cause of action. As Lord Hodge says, depending on what happened, there may be difficulties in finding any damages. The benefit of the cause of action may be that if you heard that Crédit Agricole was going to go and do something else with it, you'd get an injunction to stop them. Yeah. Although that's not wholly necessary, because if the letter of credit remains unaltered, payment, except in accordance with the letter of credit, simply doesn't produce a discharge of the debt.
Exactly.
I mean, they've given money away to a third party.
No need for it.
So you do have to bear that in mind. You have to think very carefully at every stage what is going on, what cause of action, and what, if anything, is being breached.
Would it be sensible to think very carefully about it over the short adjournment?
Yes.
Good. We'll resume again at 2 o'clock. Thank you very much, Mr. Pollock. Court's now adjourned.